Welcome back, everybody. We're at week 14 out of 15. I can't believe how fast this semester has gone. Seems like it was just several years ago we started this course. Anyway, um, I'm glad we're able to connect through these slides that we've been able to set up so that everyone gets to hear my voice over PowerPoint and also the lecture that I would have given live. So this particular week, we have two issues, two topics. Today we're going to talk about indemnification and insurance. This you'll note from the textbook is the shortest chapter perhaps in any textbook you've ever read, which is really nice. But we also had some supplemental material that is on the syllabus, specifically Ohio Revised Code 1701.13, which we're going to talk about in a lot of detail today. And we have a supplemental case, the Miller versus Miller case, which I think is an interesting distinction between different types of indemnification. And we'll get into that a little bit later. So what are we talking about when we talk about indemnification? So here's the basic concept. Directors are obviously necessary vital players when it comes to the orderly functioning of a corporation. Throughout the semester, we've looked at business decisions of directors since they're, by statute, the primary decision makers for corporations. Remember 1701.59? In the case of private companies or closely held companies that we've talked about, the identity of directors and officers are not as widely known as in the case of public companies. With public companies, as we know, there are required filings with the SEC when the company initially goes public and under the 34 Act in the form of periodic continuing disclosures about the company. If you look at the document that I sent to you along with the email that gave you the link to this lecture, there's a document that I sent you called Google One. If you look at Google One, this is essentially one of these periodic filings. This is just an example of one of them. This is a proxy statement. And it's Schedule 14A filed with the SEC. This is for Google. And I'm just giving you the first page to show you the company and to show you the type of filing that it was. And then I'm jumping down to some selected pages from the proxy statement to show you, for instance, the identity of all the directors and what committees they sit on are set forth on the second page of that Google One document. And you also scroll down, farther down to the third page of the document, you see all of the executive officers and how much they get paid. And then if you go to the fourth page, there's even more detail around the titles of the directors and officers, the compensation they make, stock awards, incentive compensation, etc. The reason I'm showing this to you is because when you serve on the board of directors of a publicly traded corporation, or you're an officer of a publicly traded corporation, your role in those respects is published to the world through the SEC's reporting regimen, which makes all of this information public. In litigation involving private or closely held companies, one of the first discovery requests that the company will receive often asks for the identity of the corporation's officers and directors. Why? Because this isn't automatically disclosed as it is with a publicly traded company, but it certainly is one of the first areas of inquiry involving corporate litigation with a private company. Both groups, officers and directors, are automatic targets in the event of litigation against the corporation, both in the case of third parties making direct claims against the corporation and cases in which shareholders initiate action against directors or officers in the name of the corporation itself, that is, a derivative lawsuit. Indemnification is the generic term for holding someone harmless. Suppose you come to work for a company on a software project that has been in process for months before you came to the job. After you come on board as Vice President of Technology, the company, including you, gets sued for copyright infringement due to content created before you started work. Since the company agreed to hold you harmless or indemnify you, the company is obligated to pay your legal fees and perhaps any judgment that is obtained against you as a result of the possible infringement for which you're being sued, but for which you aren't responsible directly. Here we're talking about indemnifying directors and officers when they're sued for performing their duties as directors or officers. In the easiest cases, the director or officer is sued by a third party simply because they hold a title of director or officer of the corporation and clearly are not engaged in any conduct resulting in the harm for which the plaintiff is suing. Because the identity of these top-line decision makers is sometimes public, as we just saw in the example of Google, directors and officers are frequently named as parties to lawsuits. The more difficult cases involve situations where the director or officer is being sued by the corporation itself in a derivative action. Remember, in a derivative action, the corporation is typically, though not always, being forced to sue one of its own directors or officers, the same officers and directors that the corporation may already be obligated to indemnify when they get sued for being an officer or a director. Should a director be indemnified in those cases, where they're possibly implicated in the underlying cause of action? What about criminal cases? If a director is found innocent, it's easy to accept why the corporation might pay for the defense. Should the corporation pay defense costs during the time leading up to the director being found guilty? A more difficult case, I would submit. What about a plea of no contest? What about a plea bargain? The reality of criminal prosecution is that the vast majority of cases resolve by means of a plea bargain. These are the situations that end up in case books like ours. Everyone should have also received from me a copy of Ohio Revised Code section 1701.13e, which is our current law on indemnification of officers and directors in Ohio. Remember, 1701.13 is the general corporate authority for a corporation can sue and be sued. There are a number of other statements of the powers of a corporation. Subsection E is the one we're focusing on here. If you have that, you might want to put your screen on a split screen and look at 1701.13. We're going to go through that in some detail. The first category I want to focus on is 1701.13E1. This basically says that a corporation may agree to indemnify an officer or a director or an employee or an agent if they were sued for serving in those roles on behalf of the corporation. Now, you'll note that there's a carve-out in the third line. It says a corporation can agree to indemnify any person who was a party to a civil or criminal action other than an action by or on or in the right of the corporation. We know what that is, right? That's a derivative action. So E1 carves out derivative actions, but says in those cases the corporation may indemnify the officer or director. There are a couple of requirements for an officer or director being sued in order to be entitled to indemnification under this first section. Number one, they have to have acted in good faith. We've talked about that before, and although it's somewhat hazy, it generally means they were acting in what they reasonably believed to have been in the best interests of the corporation, not adverse to the corporation's interests. Number two, the person has to have had a good faith belief that what they were doing was not unlawful. They can't have been aware that something was unlawful when they were taking the actions that led to the lawsuit. So they have to have thought it was reasonably thought that it was not unlawful. And if you look down through the section, you'll also see significantly that the fact that a particular lawsuit happens to end in a settlement agreement or a prosecution ends in a no contest plea, that alone does not negate the first two factors if they were otherwise were found to have existed. In other words, if they acted in good faith, they didn't believe it was illegal. The fact that it may have ended in a settlement agreement or in a plea of no contest won't remove them from eligibility to perhaps be indemnified by the corporation. The second category in subsection 2, E2, is indemnification in derivative lawsuit situations. You'll see that the statute contains the same language as E1, except now it relates to a derivative action, but there are a couple of significant carve-outs from providing indemnification to an officer or director in a derivative lawsuit. Number one, any claim, issue, or matter as to which such person is adjudged to be liable for negligence or misconduct in the performance of their duties. If there's a lawsuit, they were determined to be negligent or to purposely have done something against the corporation interest, there is no indemnification unless the court finds that despite this finding of adjudication of liability, but in view of the circumstances of the case, the person is fairly and reasonably entitled to indemnity. So there's a carve-out with a carve-out. Number two, there is no indemnification in a derivative lawsuit in Ohio if the liability asserted against the director is a violation of 1701.95. You'll recall that that is the provision basically saying that you can't issue dividends if it would render the company insolvent, improper dividends. If that is the allegation against the director, there's no indemnification. Now moving on, in subsection 3, E3, this is the first case where we see that there's a mandatory indemnification obligation on the part of the corporation. When does that happen? When is that triggered? Well, it happens if the officer or director who's been sued wins. They successfully defend the lawsuit. In that case, the corporation shall indemnify them. So who determines whether an officer or a director is indemnified? We've talked about it as lawyers, but as a practical matter, how is that decision made within the corporation? If you look at E4, it gives us a bit of a pecking order in terms of who you look to make that determination as to whether there's an entitlement to indemnification. Number one, disinterested directors. That makes sense. That's consistent with the fact that they are essentially running the show, that they should be able to make that determination of entitlement to indemnification. Number two, independent legal counsel like you. Let's say all the directors are implicated. There are no disinterested directors. Independent legal counsel, outside counsel, that means, not in-house counsel, can make that determination. Number three, the shareholders can make that determination if there aren't available disinterested directors and there's no outside legal counsel, or they don't want to engage legal counsel for that. And number four, of course, the court itself can make that determination if necessary. So we have a kind of a pecking order of decision making in determining whether one of these situations results in indemnification. I want to talk briefly about, before we talk about subsection 5, E5, the concept of advancement of legal fees. So when we talk about indemnification, we use that term somewhat generically to mean being made whole by the corporation. As a practical matter, when an officer or director is sued for doing their job, they immediately have to hire legal counsel and they immediately start to run up fees. Indemnification, in its purest sense, means reimbursement after the fact. So let's say I get sued as a director. I have to hire Jones Day to defend me. They need a $100,000 deposit, a fee retainer. And if I want to be defended, I have to pay it. As we've seen in some of the subsections we looked at, if I am successful, I shall be reimbursed for that. If in other situations, I may be reimbursed for that by the corporation. But again, this assumes that I have the money on the front end to incur those expenses in the first place. Advancement, on the other hand, is an obligation on the part of the corporation to basically front those fees to you and to pay them as they are incurred. So not having to wait until the end of the action to be reimbursed. That's the concept of advancement. Obviously, it's super important if you have someone who is going to advance you funds, then you having to take out a line of credit against your house and hope to get reimbursed later. So with subsection 5, we begin to talk about this idea of advancement of legal fees. So how do fees get advanced? Well, if we look at 5A, this speaks specifically to a director's acts or mission. It says that unless the corporation has specifically opted out of this subsection, which it has to state in its amendment to its articles or in its regulations, unless they've opted out, saying that basically this doesn't apply, and unless the only liability against the director is under 170195, which we talked about before, the corporation shall pay legal fees as incurred prior to final disposition of the case, as long as the director agrees to two conditions. Number one, the director agrees that I will repay this if it ends up that I am wrong, if I lose, and if there's deliberate intent on my part to injure the corporation or acting in reckless disregard of the best interests of the corporation. So repayment obligation. Number two, I have to cooperate with the corporation in defending the claim. Why? Because they're paying the money on the front end. They may want to have their counsel take over the defense of the case. I have to agree to cooperate with their chosen counsel in defending the case. And I think we all agree that that makes a lot of sense. Now, subsection 5B is a little interesting. This talks about expenses incurred by a director, trustee, officer, employee, member, manager, or agent in connection with one of these suits. They may be advanced by the corporation as they are incurred by that person upon the receipt of an undertaking to repay that advanced funds in case that the person loses. I admit this is a little confusing because 5A talks about mandatory advancement in the case of a director. 5B talks about permissive advancement by a director, payment to a director. I'm not sure if this is a drafting error or what the distinction is between the two subsections in that respect. I leave that to the mysteries of draftsmen who put the statute together a long time ago. So I want you to take away from this section 1701.13e these categories. Number one, permissive indemnity in non-derivative cases, as long as the action was taken in good faith, it's not known to be illegal, and of course a settlement doesn't apply a lack of good faith. Number two, indemnification in derivative cases, again, optional, except if there's negligence or misconduct, there is no indemnification unless the court trumps that carve out. And of course, in cases where there's an alleged improper dividend, there's no indemnification in derivative cases. Number three, corporation shall indemnify if the person is successful on the merits. The determination of entitlement to indemnification has a pecking order that we looked at. Directors, legal counsel, disinterested directors, independent legal counsel, shareholders, court. And then finally, this idea of advancement versus reimbursement of expenses, which has to be accompanied by an agreement to repay and cooperation in the defense of the case. All right, so we have the statutory authority for a corporation to indemnify directors and officers. But under the statute, indemnification is not mandatory except in the case of a successful defense. So how is this obligation to indemnify actually activated or triggered, aside from the statute itself? Activating indemnification. There are a couple of ways this typically happens. Of course, you will have directors and officers who will be knowledgeable of the statute that's out there, and that statute may apply unless the corporation has opted out of certain sections of it, specifically the advancement of legal fees section. Otherwise, most corporations activate indemnification through their code of regulations. Remember, you should have access to the standard code of regulations that we've been dealing with all semester. If you look at Article 5 of the template code of regulations that we've been using this semester, and which we'll continue to use and we'll have on the final, Article 5, indemnification of directors and officers, basically says, again, this is a matter of the fabric of the corporate governance of this particular entity. The first subsection of it is called right of indemnification. It says the corporation shall indemnify any director or officer to the fullest extent provided by or permissible under Section 1701(13)E of the Ohio Revised Code. It goes on to say that the corporation is hereby specifically authorized to take any and all further action to effectuate any indemnification of any director or officer who may be entitled to indemnification by authorizing it through a vote of the shareholders, vote of disinterested directors, by agreement or otherwise. And it goes on to say that this particular section of the regulations shall be interpreted in all respects to expand such power, to indemnify to the maximum extent permissible to any Ohio corporation, etc., etc. Now, this is not the statute. This is a corporation's recognition of the indemnification and advancement powers that are available through the statute. But the statute is just a minimum. Corporations can oftentimes go beyond what the statute provides. Remember, the statute itself has a certain amount of wiggle room for corporations in terms of indemnifying people. Corporations can go beyond the statute. They can enact more stringent indemnification obligations for the corporation. And that's what some corporations do for all the reasons we talked about, to recruit directors and officers, to keep everybody honest and minding the shop so they never have to pay out on one of these things. So bylaw provisions can be, I think that it's a fair statement to say that many of them have a statement saying that they will indemnify as provided by the statute, period. Going beyond that is at the option of the corporation. Now the question is, can a corporation in its articles or regulations remove the obligation to indemnify? The question and the answer is only partly. Only with respect to the advancement of fees that are in 1701(13)E5. Otherwise, the obligations to indemnify, for instance, if I'm successful in the merits under 1701(13)E3, is mandatory. And if I were an officer or a director who successfully defended myself, spent money doing it, went after the corporation for indemnification, and they refused, I would have a lawsuit against the corporation. Another way that indemnification can be activated and modified to a certain extent, is in connection with an officer's or a director's employment contract with the corporation. Yes, directors can also be employed as officers. They might wear two hats. So there might be an employment contract that spells out the obligation of the corporation to indemnify that employee. If you look at the class website under other materials, you'll find something called an executive contract. And if you pull that up, you'll see that there's a clause at the very end of that employment agreement with that executive saying, first of all, it's called indemnification and insurance. And I'll read it. The company and any affiliate thereof for which executive shall serve as an officer or director will indemnify executive both during and after his service and surviving any termination of this agreement to the maximum extent permitted by the laws of the jurisdiction of its formation relating to the indemnification of officers and directors. Such indemnity provisions shall not be changed in any manner, whether during or after executive's employment with the company, without the executive's prior written consent. What does this mean? It means that they will indemnify this person to the maximum extent, and they won't change their policy with respect to that without this executive's consent. In other words, after this contract is entered into, they're not going to go back and somehow try to opt out of certain provisions that they hadn't opted out of before. Again, this is a contractual commitment. Now it's become a contractual commitment on the part of the corporation, so that if you don't receive the indemnification or advancement you're entitled to, you have another count to your lawsuit. The first count was violation of Ohio Revised Code 170113E. The second one is a breach of contract claim because the corporation agreed to do that. That was part of the consideration that I bargained for when I entered into my contract, was this clause that gave me some extra protection in the event that the company doesn't honor its obligation to indemnify me. Now, you'll see also, though, that there is a reference to insurance in this paragraph, and there's also a reference to insurance in some of the other documents we've looked at. This is typically referred to as director and officer insurance, D&O or D&O in typical corporate jargon. We'll talk a little bit more about these D&O policies a little bit later. So who pays for this anyway? Who pays for all this stuff? Under 1701(13)E, depending on the specific triggering event, the corporation may be required to advance funds as they are incurred by the defendant in a particular case. In other instances, the corporation is committed to reimbursing the defendant. Either way, where does the money come from? How does the corporation fund its commitment to either advance litigation costs or indemnify directors and officers after the fact? Two main ways this happens as a practical matter. The first one is the corporation agrees from its own funds basically to pay the legal expenses of the officer or director. This is referred to as self-insured or self-funded indemnification or advancement of fees. The second way this typically is handled is through something called director and officer insurance I just mentioned a few minutes ago, D&O policies. Which brings us to our first actual case in this chapter, Merritt Chapman versus Wolfson from Delaware. I gave you a chart that I hope you'll find helpful in working through this. In terms of the facts, there were officers of the corporate entity that were criminally charged with securities fraud, conspiracy, and perjury in connection with an undisclosed buyback scheme. As we know from our prior weeks in class, buybacks are corporate decisions to retire outstanding shares, and that they need to be administered fairly and equally to all shareholders, have to be disclosed because they could have an impact on the capitalization, of course, and the financial health of the corporation. And there were some shenanigans with respect to this, which led to the criminal charges being brought. At the first trial, all of the defendants were guilty on all counts, except the conspiracy count, which apparently was dropped. The corporation denied indemnification to Wolfson, Gerbert, and Straub, which was upheld by the Delaware Supreme Court. The convictions were later reversed, and there were some subsequent retrials that took place. Oh, by the way, the second character of our 4-character code for today is the number 9. The second character is the number 9. Anyway, as a result of the retrials, there was a conviction on count 3 as it related to Gerbert. He was found guilty. There was a settlement of other charges, and there was a no contest plea to count 5 for filing a false report back in 1963. Gerbert agreement was not, his agreement was that he wouldn't appeal the conviction on count 3. All the other charges were dropped. So these folks asked for indemnification, and the corporation denies it, claiming that Delaware Corporation Statute Section 145C only requires indemnification where, quote, there has been vindication by a finding of innocence, period, end quote. I sent around Delaware Section 145 with the email, including the link to this lecture tonight, so you can take a look at it. You'll see that it is virtually identical to Ohio 1701-13E, basically saying that to the extent a officer or director has been successful in the merits, they shall be indemnified. The corporation takes the position that they were not successful. The trial court had taken the position that dropping the charges is not the same as innocence, since the charge included conspiracy as well. So it comes up to appeal to this court, and the argument is, the court's finding is, quote, in a criminal action, any result other than conviction must be considered success. That's on page 751 if you're happening to have that at your fingertips. With respect to count 3, the Gerber perjury count, and count 5, the Wolfson the no contest claim, they were not entitled to indemnification since they are guilty. With respect to the dropped charges, they are entitled to indemnification. So we have the court, and the reason we have the case is we see a court giving a little more nuanced interpretation of what it means to have been successful on the merits or otherwise, which the statute says. So we have a recognition of the fact that a no contest charge could certainly be considered a favorable disposition of this particular case. So you have to delve into the statute a little bit to come out with these types of different outcomes. Question, could an Ohio corporation have indemnified Wolfson and Gerber despite their guilty and no contest pleas? If you look at section 1701-13E1, the last sentence, it says that the fact that a particular case is ended in a plea or a settlement doesn't necessarily negate the finding of good faith, acting in the best interest of the corporation, and the lack of knowledge that what they did was unlawful. And I also, again, point out the fact that's raised in note 2 after this case that a vast majority of cases settle or plea out in the case of criminal cases. Just a quick aside, I think in Cuyahoga County we have about a 90% settlement rate on cases. Should a director be entitled to indemnification if the corporation pays something to settle what would otherwise be a nuisance lawsuit? You know, a nuisance lawsuit is one that, like the name suggests, there's not much to it in terms of substance, but the corporation looks at the possible costs of defending it to trial and realizes it's worth paying something to make it go away. If a corporation pays something to make a case go away, should that be considered success for indemnification purposes? This last case and some of the language that we just looked at suggests that there can be benefits to resolving cases that way. What about settling a case where the corporation has real exposure? It's minimized or avoided it by settlement. Again, that arguably is something that might justify indemnification. If you look at note 3 after the case, at least one court has held that paying anything does not equal success for purposes of mandatory indemnification. This is as good a time as ever to start to talk very generally about the fundamental principles underlying the concept of indemnification of directors and officers. Our authors refer to this, and they suggest that indemnification should only be permitted where it will promote accepted corporate policies. In other words, not indemnifying people if those people are acting contrary to what the corporation has established as its principles, as its values, through its maybe corporate governance documents, maybe HR policies, etc. Let's say an officer is sued for breach of fiduciary duty by a shareholder who's unhappy with the company's stand on global warming. Should the company pay for his defense? What does it say if the corporation does that? What if the person has done something that actually violates the company's stand on global warming? And conversely, should indemnification be denied where it might protect or encourage improper conduct within a corporation? Let's say a corporate officer decides to sue an employee who's openly gay in a jurisdiction where there's no legal protection from that, from being fired because you're gay. And if there's a wrongful termination lawsuit that's brought, should the corporation pay for the defense? If it doesn't, what does it say about the corporation's stand on human rights issues, etc.? Even if it's not required legally to defend, are there times when they should defend to support their corporate culture? I want to shift gears a little bit and talk about indemnification in derivative lawsuits. Since we've seen that indemnification statutes distinguish between routine litigation against officers or directors versus shareholder derivative actions, let's talk a little bit about those derivative cases. And remember, this is a lawsuit that is in which a shareholder requests the corporation initiate legal action against a third party, typically an insider, like an officer or director, since the corporation has failed to initiate litigation in its own name. The next digit of the code is the number 2. Next digit of the attendance code is the number 2. In this situation, must the corporation indemnify the very director that it is suing? Isn't this circular? Well, let's go back for a second and look at 1701.13E2. Per subsection 2, 1701.13E2, yes, if the person acted in good faith and in a manner the person reasonably believed to be in or not opposed to the best interests of the corporation, that sounds like fiduciary duty, doesn't it? They should be entitled to indemnification. Again, unless there's negligence or misconduct in the performance of that person's work for the corporation, and again, assuming that the court hasn't trumped that exception. What does the Delaware statute say about indemnification in the case of derivative actions? If you look at 145B, which you should have somewhere near you. It's almost identical. So for purposes of comparative law, Ohio, Delaware, some other major states have adopted this similar approach to indemnification in derivative action cases. All right, let's look at the Alyanikoff versus Goldman Sachs Group case on 753. So here we have a tech worker. He's also a vice president, leaves Goldman to work for Teza, taking confidential source code with him. What is source code? Source code is, you may not know it, maybe you do. In the computer world, that is the series of ones and zeros that make up the actual mechanical code that gets processed. It is the heart of the code itself versus the object code, which is the computer language that creates the visual that you see on your computer screen. So he leaves with the source code, and he's convicted under federal statutes. He appeals and is acquitted. However, as often happens, he's then charged under New York state law based on the same conduct. He asks the Goldman folks to indemnify him, to reimburse, for the fees for the federal proceedings and to advance fees to defend the state charges, which must be repaid if he's unsuccessful, of course. So in this particular case, the advancement was granted and the indemnification was denied as, quote, unripe, quote, since apparently he didn't provide sufficient evidence for the fees that were incurred. Again, kind of a technical, evidentiary, fact-specific outcome on that issue. So how does the court deal with this? The question is there a right to indemnification and or advancement on a fundamental level? And this goes to the question we talked about before, is how is indemnification activated? Well, in this case, we had a bylaw provision. Section 6.4 of the Goldman Sachs bylaws specifically limits indemnification to officers as determined under basic corporate governance provisions or those performing similar functions for a non-corporate entity like Goldman Sachs, which I believe is a partnership. Goldman Sachs, how do they defend? They claim that this VP title that this fellow had was a courtesy, but they really couldn't prove a difference between the appointment of courtesy VPs or real VPs. And they went on to say that the title of the particular individual was, quote, not particularly meaningful, period, end quote. This requires the court to construe Delaware Corporate Statute 145. And the court talks about the fact that the statute represents a liberal policy in favor of indemnification and advancement, and for all the reasons we talked about, recruiting, providing for internal policing of the activities of officers and directors. The court goes on to say that Goldman Sachs chose to give everyone the VP title, and that comes with consequences. That is the obligation to indemnify and to advance legal fees. Remember, we talked about something before in this semester, something called apparent authority, which is a similar concept from a factual standpoint, where if you provide a particular worker with trappings of authority, you're responsible for what that worker does as a person who appears to be authorized. Well, in this case, they granted this particular gentleman a vice president title, and this court says, well, whether you meant it or not, you gave him a VP title that brings him into the category of indemnification under your own bylaws. The takeaway, be careful how you hand out corporate titles and make sure your bylaws reflect the reality of your business. Their bylaws could have said, for instance, there's indemnification permitted for officers containing real titles versus courtesy titles. Well, of course they wouldn't have said that, but they could have created, gradations within that bylaw provision for those who have, maybe you call them senior executive officers versus other officers. They could have made an attempt to address this problem that came back to bite them in this particular instance. The next case I want to look at is the Miller versus Miller case, an Ohio Supreme Court case from 2012. This case is on the website under the cases folder. So what's going on in this case? A shareholder of Trumbull Company seeks advancement of legal fees to defend a derivative action related to his alleged diversion of a corporate opportunity. The lower court denied his request for advancement since he was not being sued, quote, as a result of any act or omission on behalf of the corporation, end quote. Rather, he's being sued for his personal dealings with the other plumbing company. The lower court also denied his request since his actions were not taken, quote, in good faith, end quote, which this court equates to the business judgment rule. So when it comes up to this particular court, the lower court, they say, confused the test for indemnification with the test for advancement of legal expenses. I'll read from the decision. They say, quote, we hold that a corporation cannot avoid its duty to advance expenses to a director under 1701(13)(e)(5)(a) by claiming that the director's alleged misconduct, if proven, would amount to a violation of his or her fiduciary duties and would therefore foreclose indemnification. This is, I would submit, exactly on point. If you look at 5A, the section of 1701.13, it doesn't say anything about good faith. It doesn't say anything about believing your actions were not unlawful. It really is a mandatory obligation to advance, unless you're being sued under 1701(95) only, unless the corporation has specifically opted out of this particular section of the statute. The court goes on to say, we hold that when a corporation has received the undertaking described in 1701(13)(e)(5)(a), the corporation is required to advance expenses to a director unless the corporation's articles or regulations specifically state that that section does not apply to the corporation. We have this court basically misreading the statute, which is not surprising since most people don't distinguish between advancement and reimbursement. You'd think the court would, but they didn't read the statute apparently. Question is, can a corporation choose to indemnify the director in this case? Yes, of course they can. Now, might you get a challenge from another shareholder saying this is a waste of corporate assets to indemnify this person when really they're not entitled to indemnification? That's a risk also, so it gets complicated. For all the reasons we talked about, the corporation may want to make a point in terms of establishing its corporate policies and procedures that may be objected to by other shareholders. I guess the takeaway from the Miller and Miller case is take care in drafting articles and bylaws. If you don't opt out of this particular section, the corporation's obligation to pay these fees could bankrupt a small company. This, again, is one of the numerous sections that I've referred to during the semester of provisions that unless you put it in your articles of incorporation or take it out of your articles of incorporation by making an amendment to the template we talk about, or an addendum to the template articles we've been talking about, unless you affirmatively put that in an addendum, it's going to apply to the corporation. I think we've talked about a dozen of these so far. All right, last case we're going to talk about is the McCullough versus Fidelity and Deposit case from 1993, Fifth Circuit case. This case deals specifically with coverage issues. Just so you know, there are actually lawyers out there who we call coverage counsel, and all they do is practice in this area of determining insurance coverage because it's such a significant issue when it comes time to actually honor these provisions for indemnification. Virtually every company I've come into contact with has insurance to cover this. And as most of you know, insurers are always in the business of not paying. So we have coverage counsel that gets involved in those particular cases. So what are the facts? FDIC was a receiver. As a receiver, they were a receiver. They sued Harris Bank's directors and officers for improperly making loans. FDIC comes in when a bank goes into receivership. FDIC is kind of like the grown-up in the room who steps in and cleans up the mess that apparently was caused by Harris Bank's officers and directors in this particular case. The FDIC, who was the receiver for the banks, sued the insurer, F&D, in a declaratory judgment action to provide D&O coverage for the directors of Harris County Bank shares under their, quote, claims made, quote, policy. Why is the entity that is suing the officers and directors now suing to get coverage for them under the policy? Well, probably because that's the only way to get dollars into the hands of the victims or the shareholders who are hurt by the directors and officers' actions. So they are suing the shareholder to provide coverage to these injured parties. So what's a claims made policy? A claims made policy, it is a policy that provides coverage for claims first made during the policy period. So you have to make the claims within the policy period. By contrast, we have something called an occurrence policy, which provides coverage for issues arising during the policy period, no matter when the claim is made. So for instance, the basis for the claim, let's say in this particular case, just use a simple example, someone slips and falls in your store during the year that the policy is in place. They don't file a lawsuit for 3 years later. If it's an occurrence policy, they still have the ability to make that claim even though it's outside of the claims of the policy period itself. So in this case, it was a claims made policy, meaning the claims had to be made within the policy period itself. What was the issue here? What was at issue? Well, the trial court denied coverage, granting summary judgment for the insurer based on lack of adequate notice of the claim. If you look at page 758, you'll see where they talk about that. And the issue is, did FDIC give Fidelity sufficient notice of these claims that they were going to be asserting against the policy? And the conclusion of the court was no. So how did the FDIC notify Fidelity about problems that might require insurance? How did the FDIC notify Fidelity about the problems that might require insurance? Footnote M to the 1984 call reports mentioned a cease and desist order from the Office of the Comptroller of the Currency, but the bank didn't provide a copy of the actual call report. They didn't provide the actual call report. So what was the bank's position? Well, Section 6 of the policy was met through footnote M, according to the bank. Fidelity's policy, on the other hand, was that they were required to give Fidelity notice of specified wrongful acts. The court here upholds that in a claims made policy, notice must be specific. Otherwise, coverage expands beyond the term intended by the policy. Here, the notice didn't even specify the actual conduct that was the subject of the cease and desist order, nor had the subsidiary itself been involved in that information flow. The point of the authors giving us this case is to help us to appreciate the fact that after you get through all of the issues of determining whether there's an entitlement to indemnification, sorting through all of the statutes and facts we've been talking about, there can be a very real issue, which is simply an insurance coverage issue. And that's what this is about. It is simply a coverage issue. And these policies are very specific, and particularly with respect to claims made policies, courts tend to be very, very tight about notice that they require in order to trigger coverage. So let's talk about D&O policies a little bit. I'm looking at around page 760 of the text. First and foremost, insurance is governed by the law of the contract. There's very little statutory law out there dictating what can be included in a insurance policy contract. At its heart, an insurance policy is a contract between the insurer and the insured, even though people might feel like you have no choice. You can always not accept the policy if you don't like what's in it. You can also negotiate riders or addendum or amendments to a policy to carve out particular risks. As a lawyer, your job is to read and understand the policy, and hopefully your client will also read it, but more likely you'll read it and you'll need to explain to them exactly what it says, since you're probably in a better position to interpret these policies than your client is. But as we know, clients are charged with knowing the content of everything that they sign, and so the defense of, well, that was 85 pages of fine print, I didn't read it, is no defense. Another factor to be mindful of is the issue of policy limits. That is, how much will the insurer pay out in the event of a triggering event. There's something to take into consideration that the possibility that in a corporate meltdown, there may be multiple claims by multiple parties based on the same or even different conduct within the corporation itself. Having high enough limits that the plaintiff is more attracted to the policy for compensation than the personal assets of the defendant, director, or officer is also important. Also, there exists the very real possibility of conflict between and among the directors and officers in a particular case. Looking back at our discussion in week 7 about representing the corporation versus representing its officers and directors, it might very well be the case, in some cases, that directors and officers will need separate counsel when requesting, demanding coverage under the corporation's D&O policy. That might not even come up until you get to the point where you're actually seeking compensation for what you think is an indemnifiable event. And that might be driven, as I mentioned just now, by, among other things, the nature of the policy, the quality of the policy, the amount of coverage under the policy that's being put in place to possibly pay for this. Next, I want to talk about, and when we talk about these types of D&O policies, there's some fairly general but recurring types of exclusions from coverage. So if you've looked at an insurance policy lately, you'll realize that the section describing coverage is pretty small and the section describing exclusions is quite large. In other words, as I said before, insurance companies are in the business of taking your money and not paying out claims. So a common type of carve out or an exclusion from insurance policy is for conduct, generally self-dealing conduct. So in our corporate world, if there's an officer or a director who's being sued for engaging in a self-dealing transaction for their own personal benefit, regardless of whether they might be entitled to advancement under a statute, there may be insurance policies that won't cover it. Another common exclusion is if there's other insurance out there that could possibly pay a claim. If there is, many insurance companies will say, then we're not going to pay. Despite the fact that the other insurance may be less, might not be as beneficial to the corporation or its officers and directors. A third type of common exclusion that we see in these policies is for, I will call them laser or risk-specific exclusions. As ironic as it sounds, there are certain exclusions from high-risk activities of corporations who by their nature engage in high-risk activities. Go figure. So for instance, there may be a policy in place to cover a corporation's risks related to everything but oil field production, for instance, when in fact that is the policy, that is the practice and the business of the insured. And there are other more specific, laser-specific exclusions for certain types of activities. For instance, environmental contamination can be a specific carve-out from a policy. Some other common exclusions that we see in business policies are exclusion from coverage for insider trading. Let's say your director or officer is charged with insider trading, violation of federal securities laws. It's common for that to be a very specifically spelled out exclusion from a business policy. Another common exclusion is a return of illegal remuneration. Let's say that someone is charged with or sued for making an improper dividend to, let's say, themselves, and they are asked to reimburse that money to the corporation. A lot of policies will say, sorry, that's not an insurable risk. If you engage in that type of activity, we're not going to help you with that. So that's a common carve out as well. And of course, there's a common carve out for misrepresentations in the application process itself. Another area that we see these policies modified through are something called endorsements. Endorsements are modifications to the main policy itself, which will be written to address a particular situation in the life of the person who's applying for the insurance, like the corporation, for instance. A common endorsement is for pending litigation, saying that we're not going to provide any coverage for this particular lawsuit that's pending, or for facts that we know about should they turn into litigation sometime in the future. Another common endorsement is an endorsement that basically says there'll be no protection if action is taken against the director or officer by state or federal regulators for a particular issue that we know is percolating up through the corporation itself. On the website for our class is an actual E&O policy issued by AIG, and that is under other materials on our website. And if you pull it up and take a look at it, I've done some highlighting on this particular policy, so you can see the sort of coverage that typically gets put in place. They distinguish between coverage of the executive or the director or officer versus coverage of the corporation itself as the insured. And if you look at this, this is a fairly short summary of the policy. This is only 18 pages. It defines what a claim is, of course. It also it defines what defense costs mean. If you have any doubt as to whether things related to a lawsuit might be included, not just legal fees, but investigation fees, for instance. It talks about, in this particular case, there's an exclusion for employment practices that violate law. And this is also a common exclusion. Most insurers don't cover you for things like sexual harassment, wrongful termination, etc. They would be happy to sell you a special policy just for that, but it's a common carve out. It defines what a covered executive is. Past, present executives are pretty common, and they have to have been appointed or elected by the directors. And we see some definition as to what those people are strictly defined. Some other things, they talk about what a loss is. Well, a loss is civil or criminal fines and penalties, can be taxes, can be punitive or exemplary damages, can be a multiplier of those if that's how the judgment is rendered. And it also talks about things like, for instance, they say no liability. What does no liability mean? Well, remember we talked about the fact that indemnification is sometimes mandatory if there's a determination by the court that there has been, that the defendant has not done anything wrong. And basically in this particular statute, we saw in our statute that A settlement agreement doesn't necessarily mean that a person didn't act in good faith and without knowledge that what they were doing was illegal. However, we flip over here to the insurance policy. It has a specific provision that says, in no event shall the term no liability apply to a claim made against an insured for which a settlement has occurred. Just the opposite. So again, we have the reality of the indemnification law versus the reality of the insurance policy itself. No matter what may apply or result from a pure indemnification law analysis, the insurance policy may see something different. You'll see that this policy has a carve out for securities claims, securities fraud, fraud on the market, insider trading, either brought directly or derivatively. There's no coverage for those. Again, they'd like to sell you a separate policy, but that's not going to be included in the general business policy, not even the general D&O policy in this particular case for AIG. And this policy also contains some of the other self-dealing exclusions that I talked about before. Again, for you as a lawyer, why should you care about what the D&O policy says? Well, if you are the corporation, and this may be the difference between insurance providing the indemnification or the corporation having to come up with the funds out of its own pocket. If you're the officer or director to whom indemnification has been promised, you'll want to know whether the insurance will do the job. If not, you need to get comfortable that the corporation has other available assets to fill the gaps in coverage. So, and of course, if you're the lawyer, believe me, your clients will not have read these policies. Most people haven't read these policies except lawyers. So if your client, you're setting up a client and they're a small company and they're going to buy a D&O policy and you've given them the speech about why they might want to have a D&O policy to fund indemnification, you got to make sure that you read the policy and you provide them with the executive summary version focusing on these big points that I mentioned so that they don't have a rude awakening when the first time they have to make a claim under the policy, they're told that they don't have coverage for any of the reasons that I mentioned as we talked through some of the exclusions. And just a quick aside, I don't know if you remember when we talked about rendering annual reports by private companies. Remember, private companies still have to publish their annual financial statements to shareholders, even if it's a three-person corporation. Remember, the statute says in Ohio that the corporation has to have had those financial statements audited or they're vouched for by the president of the corporation. Let's say you're wrong. That might be the type of claim that gets you sued by being a director, for being a director. This arguably would fall under a D&O policy of coverage. Okay, I think that's more than enough on the subject of insurance and indemnification. Again, I just want to emphasize there'll be something on the exam dealing with 1701.13E. So make sure you've read it. Make sure you understand some of the nuances that we've talked about today regarding what triggers it, when is it optional, when is it mandatory, what's the impact of a derivative suit versus direct suit in terms of analyzing indemnification. On Thursday, we are going to talk about corporate dissolution and winding down. This is kind of the end of life for a corporation, and it's really important. In fact, we've had major changes to this law take place in just the last 5 years in terms of legislative enactments. And we're talking about 1701-86 to 1701-883. These are almost like a mini bankruptcy proceeding that has to take place when a company goes out of business now. So we're going to talk about that in some detail. It's really nuts and bolts corporate law that I think you'll find a good kind of near the end of the semester discussion. There are a couple of cases that I would like for you to read for this section. I believe they are both on the corporation website. So please read them. So this will all make much more sense to you if you've taken a look at them. Otherwise, I hope everybody is staying safe and healthy, and I look forward to being with you sometime soon. Bye-bye.